Welcome, everybody. Welcome to the 16th annual Frank M. Coffin Lecture on Law and Public Service. My name is Peter Pittigoff. I'm Dean of the University of Maine School of Law. The Coffin Lecture is always a very exciting time for us in our law school community. And we're especially honored this year to welcome Judge Judith Kaye, Chief Judge of New York, as our honored lecturer. Judge Kaye is a distinguished member of the Judiciary and a leader in court innovation. Welcome, Judge Kaye. Also joining us tonight on the podium is our own Chief Justice, Maine Supreme Judicial Court Chief Justice Lee Softly. Justice Softly, in a few minutes, will present a more extended introduction for Judge Kaye, our featured lecturer. Thanks, Chief, in advance. And tonight, of course, here is Judge Frank M. Coffin, for whom this lecture series is named. His is an inspiring career in public service, from his early years at the Agency for International Development and as a member of Congress, to over 4 decades as a federal circuit court judge. He has demonstrated consistent support for social justice in so many ways. And at the risk of embarrassing the judge, let me announce a public celebration of Judge Coffin's extraordinary commitment to justice. Just a week from this coming Monday, on November 17th, from 5 to 7 p.m. at the Holiday Inn by the Bay in Portland, there will be a celebration of Judge Coffin's public service career and all that he's done to promote justice in Maine and throughout the country. It's an event co-sponsored by the University of Maine School of Law, Pine Tree Legal Assistance, the Maine Bar Foundation, and Portland area law firms. So please join us if you can for that celebration. But tonight, we're here for the annual Coffin Lecture. Without a doubt, the best part of my job as dean is to know and work with Judge Coffin. Not only brilliant and public-spirited, but also creative and kind and generous. A wonderful friend to the law school and to us all. Now it is my sincere privilege and honor to introduce Judge Frank Coffin.
Dean Pittigoff, members of the faculty and student body of our Maine School of Law, distinguished fellow judges, and friends and fellow citizens. I had planned to open my remarks by referring to the style of recent public utterances, which always seem to have the same formula. And I was going to say, I am Frank Coffin and I approve this message. So I have to change it. I approve the dean's message except for his extravagant remarks. But we'll move on, and we have other reasons for celebration. This is an occasion to pay honor to the state judiciaries by honoring one of their most preeminent representatives, Chief Judge Judith Kaye of New York. She was the first member of her sex to gain the highest position in her state. She has been tapping persistently at that rather crumbling glass ceiling for 4 decades. She is revered by people throughout the country for her work, not only on her own court, but in her state and also across the nation. This is also an occasion, as the Dean has said, to pay recognition to our own Chief Justice, who also is the first woman to have reached the highest position in our judiciary. And it is therefore very fitting that Chief Justice Lee Softly join us on the platform. First of all, welcome Judge Kaye. Thank you for your loyalty and steadfastness in accepting not one but two invitations to address us. The first was in 2006, but in that year her dear husband, revered by all who knew him and highly respected attorney, developed a terminal illness. We did not try to find a substitute for Judith Kaye, but later we had the courage to ask if she would come back this year, and happily she did. So we are honored and appreciative of her generous act. It's also a somewhat foolhardy act. We have had, prior to Chief Justice Softly, another Chief Justice, Dan Wathen. I urged him not to come to this affair, but I'm afraid he is here tonight. But he is somewhat of a Jonah as far as Judge Kaye is concerned. It began some years ago at a Chief Justice's conference in Monterey, California, where one early morning, Judge Kaye was indiscreet enough to walk along the beach with Justice Wathen. It was not only a sandy beach, it was a beach packed with sand with the resilience of concrete. Not surprisingly, when she got back to New York, she had knee surgery. Several years later, the Conference of Chief Justices occurred in Rockland, Maine at our own Samoset Hotel. Happily, Dan Wathen was no longer Chief Justice then, but nevertheless, he had been asked to address the conferences, and he did so. Early the next morning, Chief Judge Kaye walked out alone on the breakwater in Rockland and predictably broke a leg. And so as Chief Justice Wathen warned me, he said, please exhort your audience tonight as the performance go ahead to avoid that customary stage good wish of break a leg. So with that in our background, we will say we're particularly fortunate to have Judge Kaye in the closing days of a long and spectacular career. She must retire at the end of this year, December 31st. It has been a great ride. And that's a sad note. But the happy thing is that a few years hence, the Coffin lecturers might very well ask Judith Kaye to come back and say, what is her next chapter on the contributions to the common good that she undoubtedly will make. Well, I've asked Chief Justice Softly to really talk about Judge Kaye in somewhat more detail. I talk only about a couple of things. The first is the inauspicious beginning of Judge Kaye. Ruth Bader Ginsburg of the Supreme Court has told the Association of the Bar of the City of New York that Chief Judge Kaye began after college with the dream of becoming a star reporter. Well, she wound up, the best job she could get was that of being society reporter for a New Jersey newspaper. Well, what did she do next? When that collapsed, Judge Kaye has said what she did next. She consulted that eminent vocational counselor in New York, Yogi Berra, who said, when you come to a crossroads, take it. And she did, and as Justice Ginsburg said, that made a big difference. There was far more upward mobility in the law than in reporting at that time. So, as Robert Frost said, there are many roads to travel. The road she traveled is full of honors, cases, causes, and we shall let Judge Softly deal with that. My chief focus is on something that I found very interesting, which was her style of leadership. Some years ago, 2002, she was honored by Fordham University when she got the prestigious Fordham Stein Award. And Dean Traynor of Fordham talked about her approach to problem solving which involved utilizing the authority of the courts plus the resources of the community to solve endemic social problems. Later on in the Judicature magazine, the authors traced this kind of leadership through her decades-long fight for jury reform in New York. They commented how this was met by initial resistance on the part of jury commissioners, clerks, and staff, but the resistance was overcome by Judge Kaye's cautious, patient, working with everybody, being warm, being human, being flexible, listening to them. They call this transformative leadership, and that she has certainly symbolized, which is a good point to switch to Chief Justice Softly, who's following in the same footsteps. Like Judge Kaye, she has found the law a place of considerable upward mobility in her case, having gone from district judge to superior court judge to associate justice to chief justice in not much more than 10 years. She's also a problem solver. She has built upon Dan Wathen's adult drug courts by instituting juvenile drug courts and family drug courts for parents and business courts for addressing economic problems that are so important to people at all levels. And finally, she has worked well with the legislature, sensitively inviting the Judiciary Committee and others to visit the courts of the state and talk with lawyers and with judges. And she has most recently shown an instinct for looking to the future with our younger generation, and she and her court, her colleagues, have instituted the custom of visiting high schools all over the state, holding oral arguments in those schools, and conducting real honest-to-goodness arguments with the hope, not always vain, that the students listening will forego their text messaging for a time and learn a little bit of a coach. It is my great pleasure to introduce, by way of honoring Judge Kaye, to introduce our own Chief Justice, the Honorable Lee Softly, Chief Justice of the State of Maine.
Good evening, everyone. Some of this will sound familiar. When Judge Coffin says to you, we would like you to introduce Chief Judge Kaye, and if you don't mind, I might say one or two words first. I just want to say, let's see, first on the bench, jury reform and breakwaters in Maine. Thank you very much. It's been lovely speaking with you. One caution, though, before I take a real moment to talk about Chief Justice Judith Kaye, who's truly been a mentor to many of us on the court, I do want to just take this one moment and follow up on something that Judge Coffin just told you about. We did, in fact, take the court into the high schools. And we've done this about 4 years running now, and we find that the students are alternately bored to tears and extremely engaged. Many of them attempted to text, but the teachers are all over them with their cell phones. And we had quite a remarkable experience on a number of occasions. But the most fun was talking to the students after oral argument. And the interesting part, and if you get a chance to talk to any of my colleagues, you should ask them about this, because the most interesting part is to say to a group of 10 or 15 high school students ranging from ages 15 to 18, what did you like most, what did you like least? And there were some wise and articulate comments, there were some interesting comments, there were a few children who were sort of in a coma, but my favorite comment was when I said to the students at one high school, a lot of students had come, the teachers had done an enormous amount of preparation, and the arguments had been, we on the court thought, very lively. I said to them, what surprised you the most about the arguments? There's silence, they all looked at their feet, they all shuffled, and I said, oh, please, tell me the truth. And they all pointed at one young man who's obviously the spokesman for the group, and he said, well, what really surprised us was the lawyers. And I said to them, why? In what way did the lawyers surprise you? And he responded with 2 words, they sucked. And so we spoke with the lawyers afterwards and recommended that in future arguments they be a little bit more animated and perhaps try to engage the students. So, and that is a complete frolic. I will now get back to the points at issue. So let me just tell you that before I give you some of the background on Chief Justice Kaye, you need to know that next week she will give her State of the Judiciary address. And she is in her last 2 months of sitting as Chief Justice. And to be here with us today, being gracious and generous with her time, when most of us at this point in our year, every year, are pacing, muttering, occasionally engaging in profanities. Justice Wathen did that, I don't do that. And really trying to figure out exactly what it is we're going to say to the legislature next week. Look at this woman. She's calm, she's composed, she is my hero. So, with that, let me give you a little bit of background. I have to say that it's really an honor to be here, to be introduced by Judge Frank Coffin, who is universally admired, and then to be introducing Chief Justice Judith Kaye, and I feel very much the thorn between the roses, but I'm going to get right to the issues. Chief Justice Judith Kaye is a remarkable person, and from my perspective, all the more remarkable because she's not a Mainer, which is pretty unusual. Most remarkable people, as you know, all come from Maine. She was actually born in the Catskill Mountains of New York and went off to Barnard College at the age of 15. And after, and this will get a little redundant with regard to Judge Coffin's remarks, I'm not bitter. After a brief career in journalism, which apparently was not as exciting as she might have thought, and after graduating from NYU with Justice Glassman, she was offered a position at a prestigious firm of Sullivan and Cromwell on Wall Street at a time when women were a rarity. And later, again, very much like our very own Justice Caroline Glassman, Justice Kaye was appointed as the first woman on the New York Court of Appeals. She's had a long and distinguished career as a jurist, and she's been a Chief Justice for 15 years, which I am here to tell you, and I think Chief Justice Wathen will back me up on this, is a very, very long time. We've been through budget issues, legislators who really are not all that fond of us, governors who smile and then don't do what they say they were going to do, and occasionally judges who get mad at us over a variety of things, and to do that for 15 years with grace and humor and some extraordinary work is really a wonderful career. You have already heard that Chief Justice Kaye brings to her work a unique combination of warmth, humanity, and, don't let her kid you, steely determination. She's been an extraordinary inspiration to those of us who struggle to maintain the public's trust and confidence in the court system. And her work in jury reform is actually legendary. When Chief Justices across the country now look for a model for effectuating reform and change, we come back to C.J. Kaye's jury reforms. The reforms were sweeping, and they came at the problem of limited and stilted jury pools from every angle available. It's a testament to Justice Kaye's approach to problem solving that no one aspect of the reforms actually stands out above the others. She knew that to make real changes, the efforts had to involve all the stakeholders, be broad spectrum, and be implemented without flinching. Here's where it gets interesting. The juror reforms that were accomplished under her leadership extended from the sublime to the ridiculous, all the way from broadening juror lists, creating jury hotlines, and producing jury orientation videos, to one of the simple expedients that apparently actually changed the way jurors thought about their work more than any other. She made sure that juror bathrooms were regularly cleaned. Now that may actually sound absurd, but for any of you who have worked in buildings run by government, getting those bathrooms cleaned regularly can be a real feat. She's been a creator and a problem solver with regard to all of the new courts, and you heard about drug courts, domestic violence courts, and recently, as the nation struggled with what felt to us like a stalled effort to reduce child abuse and neglect, Chief Justice Kaye has helped lead all of the Chief Justices in the nation in finding collaborative and community-based solutions for families who so desperately need comprehensive and focused judicial attention. She really has worked to address the difficulties with provision of legal services to the indigent in both criminal and civil cases, and she recognized the exclusion of businesses from our public system of dispute resolution before many of us had ever tumbled to the fact that they were leaving the courthouses in droves. And her business courts have inspired us to try that in many of our states. Now, I could, and perhaps to your joy, would go on for hours about the transformative work of Chief Justice Judith Kaye, but I want to tell you that this brilliant, effective, and inspiring woman is actually one of the kindest human beings I've ever met. And that's the quality that stands out for me. In a world of ambition, brilliance, success, and in fact, competition, meeting a truly kind person seems like a rarity. And now I want to give you an example. Shortly after, and I'm actually very glad that Chief Justice Wathen is here, because every chance I can to take a shot at him on this, I like to. Shortly after September 11th, 2001, which was a very sad day for all of us, Justice Wathen called us by phone. I just want to make this clear. Called us by phone and said, I'd like to talk to you about a little something that's happening, and that is that I'm resigning as Chief Justice. We had no clue it was coming, and of course all of us immediately assumed that he had a fatal disease. Turns out he was running for governor. Close, and as I understand it, it felt pretty much like a fatal disease. So shortly after that, about 2 months later, I found myself standing, raising my right hand, and having the opportunity to be Chief Justice of this state. And it was a stunning event. Things changed very fast, and I was trying to get my feet under me, trying to figure out what the job was all about. Chief Justice Wathen, having moved to focusing on another branch of government, was not available for guidance, mentoring. What the heck do I do with this, Dan? But there is one thing he did do. I passed him in the halls of the judicial branch one day as he was taking out the last box, and he said to me with a big smile, "Did I mention to you that I committed Maine to hold the Chief Justice's conference this summer?" No, you didn't mention that. And he said, "You're going to enjoy it. Good luck." And he was gone. 50 Chief Justices, people who knew what they were doing, people who were committed to justice, swooped into the state of Maine, and I had to have everything ready. Now, the scariest thing was, Chief Justice McCusick took me aside and he said, if you get an opportunity, you should try, if you can, to spend a little bit of time with Chief Justice Judith Kaye. She is brilliant. Now, when Vincent McCusick tells you that someone is brilliant, and you are already feeling not necessarily quite capable of doing what you're doing, seeing this brilliant person is not the thing that's top on your list. So, it was with quite a bit of trepidation that I was looking forward to meeting Chief Justice Kaye at that wonderful event at the Samoset. But, and this really is indicative of this wonderful woman, she sought me out and she told me that she had never seen such a Chief Justice conference well done, that it was absolutely beautiful, and that she was amazed at my talents for putting together this wonderful meeting, which caused me, because I am this much a fool, to stand for about 10 minutes after this thinking, well, I guess I'm pretty good at this job. Then I remembered that she is a wonderful woman and that, in fact, there were all kinds of other people that had done the work. But for 10 minutes of my life, I felt capable and competent, and she did that for me at a time that was very difficult. The other thing that really brought it home to me was, after that brief meeting, and you've now heard the tragic story, she went out onto the breakwater at the Samoset and suffered a very, very bad broken leg. And the boats had to come, take her across the water, take her off to another hospital. She is then whisked away to New York. And I am left knowing that I am the Chief Justice who has ruined Chief Justice Judith Kaye, who is beloved by everyone. I don't know how to face Vincent McCusick, and I'm still thinking very bad thoughts about Dan Wathen. So after this has happened and everything begins to wrap up, I finally reached Judith at home in New York to tell her how terribly sorry I felt about what had happened. And this kind woman, the very first words out of her mouth were not, "ow," or how horrible the rocks on the breakwater were, but she said to me in this wonderful, warm tone, "Lee, did you know that Maine has a wonderful health care system? You should be so proud to live in Maine." Now, that is a kind person. We all know the quote from Ralph Waldo Emerson about a life well lived: to laugh often and much, to win the respect of intelligent people and the affection of children, to leave the world a better place, and to know even one life has breathed easier because you have lived. This is to have succeeded. Chief Justice Judith Kaye has truly succeeded, and I am just honored to welcome her here tonight.
Thank you. Thank you. Thank you all so much. Chief Justice Softly, my dear friend Lee, thank you so very much for that extraordinary introduction. Judge Coffin, for yours. Dean Pitagoff. If I were really, really brilliant, I'd just stay seated and not say another word. Don't you agree? But I do have to affirm that it took a lot of courage to come here today, given my past experience with Chief Justice Wathen and the events of that fateful Chief Justice's conference when I was carried by a police boat to Penobscot Bay, but I did receive excellent medical attention, and I'm just thrilled to be here with you this evening. I am completely and painlessly upstanding on two legs, and I'm just delighted to give this prestigious lecture that honors a true hero of mine, and that's Judge Frank M. Coffin. Now, the invitation described Judge Coffin as, and this is a quote, a legend in New England, and especially in his native Maine. But let me enlarge upon that just a little bit, because Judge Coffin is a legend not only in his native Maine and New England, he is a legend throughout the entire nation. As you know so well, he retired from active judicial service in 2006, having magnificently served on the First Circuit for 41 years, 11 of them as Chief Judge. And while many of us would say he left prematurely, he opted for what he called yet another change in role identity, and he concluded an article called Transitioning for an After the Bench series in the Journal of Appellate Practice, which I read diligently, with these words. So you ask, how is your new life working out? Oh, there's a lot to tell, but right now I don't have the time. I have to get back to the journals, and there's a carving in my shop that needs work, and oh yes, I have to finish my piece for After the Bench. Now, Judge Coffin is an inspiration on so many levels for every one of us, but just at this very moment in my own life, I feel he is speaking very personally and very directly to me, because this, as you have heard, is my transitioning period in 55 days. My judicial service comes to an end at 25 plus years because our state constitution provides for mandatory retirement at age 40. And I particularly enjoyed a quotation Judge Coffin included in that very article. He said, "Our lives are two if we can relish our past life anew." So under the banner of law and public service, I thought I'd take this occasion to relish with all of you my own soon-to-be past Chief Judge life. And what I'll tell you about my life on the New York courts, I think, is replicated more or less in state courts throughout the nation. So I'll begin by telling you what I have been doing since my appointment to the Court of Appeals of the State of New York, that's our highest court, back in 1983 as an associate judge, and then since 1993 when I became the Chief Judge. Each time I was appointed by then Governor Mario Cuomo, and I was the first woman in the role. Not as significant in retrospect as it was for me back in 1983, when I honestly feared that any misstep was going to reflect very poorly on my sisters. You know what I mean. Can you believe what that woman did, or what she said, or what she wrote? I did honestly worry about that. But as Chief Judge, actually, I have two roles. Being the Chief Judge of the state's High Court is an adjudicative role. I serve as a member of a great common law court, like Chief Justice Softly, one of 7 equals in the state of New York. And the other role, as Chief Judge of the state of New York, is an executive administrative role. I'm the head of the huge, sprawling judicial branch. We have close to 16,000 employees in the New York State court system. We have 365 courthouses and roughly 4 million new filings every single year. So I figure I spend about 80% of my time as Chief Judge of the Court of Appeals and the other 80% of my time as Chief Judge of the State of New York. I want to speak a little bit about my adjudicative role, and quite frankly, at the outset, that was the more comfortable part of my Chief Judgeship, since I came to it after serving as a member of the court for a full 10 years, and I had 6 very supportive colleagues. Now, the appeals that we hear, that all state courts hear, cover a range of subjects that just defies human imagination. You know the quote of Alexis de Tocqueville, and he was entirely right. There's hardly a political question in the United States that does not sooner or later turn into a judicial question. The state dockets are proof beyond a shadow of a doubt of that proposition. Now, any day at the Court of Appeals Hall in Albany, we could be hearing argument on legislative versus gubernatorial budget-making authority under the state constitution, and the very next case can be a slip and fall on a patch of ice, a multiple murder, raising federal constitutional issues, a global merger that's gone sour, a case of child abuse, termination of parental rights, even a teacher's claim that his right to tenure under the education law had been violated. Truly, the range of issues before our state's courts, common law, statutory, constitutional issue is limitless, cases of enormous importance to the law and to the litigants. Additionally, today, even when civil cases that come before us or criminal cases involve issues that seem to be familiar on the law, they are often raised in very dramatically different factual settings from the precedents that guide our decisions. And that's not surprising, since we have such a dramatically changed society shaped by breathtaking advances in medicine and science and technology and culture, in a shrinking and warming and flattening world. But just think for a moment. These days, we have suits for equitable distribution of property in divorce when the property to be distributed is the couple's frozen embryos. Or we've had a case under our state's adoption statute, first written in the 1870s, when the issue is adoption by the same-sex partner of the biological mother. Or consider a case under the venerable statute on child neglect, when the issue is whether mothers who are victims of domestic violence can be charged with neglect simply because their children witnessed the beatings. Or consider applying the words of our centuries-old constitutions to contemporary issues like DNA evidence and same-sex marriage and mental health research on human subjects, even the constitutionality of state taxation on telecommuters. We sit in medieval garbs, we sit in hallowed halls, seemingly removed from life to resolve cutting-edge legal questions in a world of dizzying change, providing stability in the law so that people can guide their future conduct and preserving our timeless values and principles. I like the observation of Linda Greenhouse when she was reflecting on her New York Times career and speaking of the United States Supreme Court. She said, "Continuity and change, the entwined spirals of a double helix, are the court's DNA." I think indeed that is the court's DNA for all of us. Whatever the subject, judges apply familiar tools of construction and interpretation, trusting that the efforts of outstanding counsel who come before us, combined with our own diligence and skill and good sense, will yield a result that works well for the future. Very often, I think of one of my predecessor chief judges, a name familiar to many of you, I'm sure, Benjamin Nathan Cardozo, who, for example, in the case of McPherson against Buick Motor, perceived the larger implications of a village stonecutter's vehicular misfortune and forged a new rule to better serve the emerging social realities. Cardozo and his three colleagues in the majority, by contrast to the judges in the dissent, saw that the case raised an issue emblematic of a society that was becoming increasingly motorized and mobile and mass-produced. So should a manufacturer be liable for injuries sustained by a remote purchaser of a defective product? Well, every law student knows the answer. And therein lies the challenge that we face in every case, to apply precedents of the past to reach a result that is both just for the present and anticipates the unforeseeable future. Or, to put it in the eloquent words of Judge Coffin, and I quote, "Sound decision is more than a result. It is an edifice made up of rationale, tone, and direction. It is faithful to the past, settles the present, and foreshadows the future." Beautifully put, Judge Coffin. All in all, quite a challenge for the courts, I would say. Quite a challenge for the lawyers, absolutely a challenge for the lawyers. And I take that same challenge, and indeed those same words, to my other chief judge role as Chief Executive Officer of the state court system, remembering always, Judge Coffin, that sound decision is more than a result. We need to be faithful to the past. We need to take the best of what has been built before us. We need to deal fairly, justly, and effectively with the present, and we need always to have in mind in everything we do to anticipate and foreshadow the future, which very soon, very quickly, is upon us. Although my responsibilities as Chief Judge of the Court of Appeals present very anguishing dilemmas, it is the demands of that second box of stationery, the Chief Executive Officer role, that are consistently the most bedeviling. It's that box of stationery that presents the most headaches, simultaneously providing tremendous opportunities to improve the delivery of justice, to find better ways to serve emerging social realities within our stable and tradition-bound system. And I know you will forgive me if I sidestep the most bedeviling issue of my entire tenure, and that is critically inadequate judicial compensation. I am simply enjoying my day with all of you much too much to talk about the critically inadequate judicial compensation. So let me just turn that page. And I see that entire issue in my tenure as Chief Judge summarized in the quote, "Other than that, Mrs. Lincoln, did you enjoy the show?" It is, and I'm sure, Judge Softly, you feel the same, right? Of course, in the Chief Executive Officer role, I have help that's not available in my other role. I have a Chief Administrative Judge. I have administrative teams, technological advances to improve the effectiveness of what we do. I have innumerable opportunities for collaborations with our terrific bar, with our partners in government, and I'll reserve decision on them as well, and with the broader community. To give you a better sense of that second title, Chief Judge of the State of New York, I thought I would focus tonight on two consuming initiatives, and I guess you can guess what they are, having heard from my introducers. The first is jury reform, and the second, problem-solving courts, each directed at using our resources effectively to improve the delivery of justice in today's world and promote public trust and confidence in the courts. And talk about the past by starting with jury reform. I begin centuries ago with our prized American jury system, a core element of this great democracy. It's astounding to think that the United States in the 21st century has more than 95% of all jury trials in the entire world, and that a third, more than a third actually, of all Americans are likely to be impaneled as jurors during their lifetime. So given the enormous importance of jury trials to the parties and the law, we naturally want the jury system to function as effectively as humanly possible, but there's an additional lure for every chief judge, and that is that we call a huge number of citizens into the courts, many of them having their own firsthand personal encounter with the justice system. Never mind the terrible things that they see and hear on television and read about us in popular fiction. Jury service gives us a unique opportunity to show a cynical and distrustful public that the justice system really does work well, and the justice system really does value them, their time, and their services. It's an opportunity that we simply cannot squander in today's world. Yet I remember very well my days in trial practice when receiving a jury summons, at least in the state of New York, not in Maine, I am sure, was as welcome as a tax audit or a root canal. The reality of jury service just didn't begin to match the rhetoric. We were calling the same limited group of people, poor souls, every 2 years like clockwork, and they served an average of 2 full weeks. And a reason for that, really the essential reason, was that our statutes in the state of New York allowed dozens of automatic exemptions and disqualifications. We had disqualifications for judges, of course, for lawyers, for doctors, for clergy, for police officers, firefighters, for elected officials, of course, for embalmers, for podiatrists, for people who wore prosthetic devices, for people who made prosthetic devices, to individuals with principal child care responsibility. Every group that could get to Albany and lobby the legislature got one. So we were left with a very severely depleted jury group. And these poor people, every 2 years, came for a minimum of 2 weeks service. If they were on a criminal jury, they were automatically sequestered during deliberations. And our jury facilities were admittedly quite shabby and dilapidated. So we convened a group of lawyers and non-lawyers back in 1993, academics, to review the subject and give us a report top to bottom on what we could do. Everybody was very enthusiastic about doing this and handed us a blueprint for reform, and we immediately set about to do it. Yes, we got the legislature to wipe out the automatic exemptions, the automatic sequestration, and we used the improvements, the authority we had to make improvements to better distribute the benefits and burdens of jury service. Now, I think quite honestly today, even though there have been tremendous improvements in root canal surgery, that people would prefer a jury summons to a root canal. I really do. I know that the experience can be life-altering for jurors, and I've had even friends who tell me it was one of the great experiences of their life. I don't hear that a lot, I have to admit, but I have heard it spoken, and that's because today people are sitting in well-run, well-equipped courthouse settings, fully respectful of their time and service. And across the nation, state courts working collaboratively have made jury service much, much better, much more effective. We're looking at jury service through the eyes of jurors instead of through the eyes of lawyers or court administrators. We're asking jurors what they think. We're listening to them. We have hotlines. We have emails about jury service. We have good people in our jury rooms, well-trained and attentive to their needs. What about the future? Well, unquestionably, technological change has helped drive us forward and will continue to do so. Today, summoned jurors can use the web to request a postponement. Computer software can help us better predict how many jurors we'll need. But important as technology has been, it's also brought us some new problems. And I think of ways that it can jeopardize the functioning of a trial or violate a juror's privacy. It's also part of the reason that so many of us learn differently in this new age. And here again, there are tremendous, tremendous challenges for the courts. Chief judges are duty-bound not only to keep their minds open to new insights and discoveries throughout the nation, but also to keep the topic of jury reform alive and in the forefront, to continue building on the past. Again, to get back to Judge Coffin's words, continue building on the past to assure the vitality of the institution of the jury for the present and to anticipate the future. Only in that way does our prized American jury system truly continue in a constantly changing society to serve its noble purposes and remain an anchor that holds us to the principles of our Constitution. So I'd like to turn to my second, entirely different challenge, the challenge for chief judges everywhere, which centers on today's state court dockets, most especially on the repeat low-level offenders in our state courts, often drug addicted, corroding their own lives and the vitality of our neighborhoods. And on the domestic violence cases, too often beginning with an assault and a court-issued order of protection and ending with a murder-suicide. And we need to focus on the child neglect and abuse cases, foster care cases, juvenile delinquents, children with children of their own, generation after generation of poverty and homelessness and mental illness and unemployment and crime, who we graduate from family court to criminal court. What a waste of lives. What a waste of our resources. So as we study our court dockets, we can simply watch the numbers rise, or we can ask ourselves, are we using our resources as effectively as we possibly can? Can our repeated court appearances and court interventions perhaps help to stop the deadly downward spiral of these lives? Are we simply making cases, are we simply counting cases, or are we making every case count? Now, I was encouraged to speak about my own experience in answering those questions, knowing that my friend, Chief Justice Sofley, and the Maine Judiciary are also committed to problem-solving initiatives with drug courts and mental health and behavioral courts, a co-occurring disorders court, and a domestic violence coordination project. Our own first venture, a full 15 years ago, was the Midtown Community Court, and I encourage you all to come visit us. It's smack in the middle of the Manhattan Theater District, and it's focused on quality of life crimes like shoplifting and illegal vending and vandalism and prostitution, the kind of repeat conduct that angers and erodes neighborhoods, overfills court dockets, and sends offenders on a steady descent into an abyss of worsening criminal conduct. Today, we have 8 community courts in New York State, each its own local product, but with the same core elements, beginning with a dedicated judge in the leadership role of decision maker and convener of all the collaborators necessary to assure maximum information and maximum opportunity for a meaningful resolution. Offenders, after pleading guilty, typically receive sentences of community service designed to help restore the neighborhood that they have harmed by their offense, for example, by removing graffiti. And those sentences are very closely monitored, and they are actually served to the letter. And third is a recognition that these offenders most often need additional help, which is made available to the court, through the court, including drug treatment and mental health referrals and job interviewing and employment services. At the Midtown Community Court, they can even collect their welfare check. In our state, these courts are, by the way, they are not created by the legislature by statute. They are created by the courts using their own administrative and rulemaking authority. And we study these courts constantly. We want to be sure that we are using our resources well. But in addition to the statistics, we know they are working effectively because we hear from the neighborhood associations. We hear them express satisfaction, even praise, for the visible impact of these courts on the community. It's the graduates of these courts, as we call those who successfully complete the programs, that tell us that for the first time in their lives, they have obtained jobs, they have obtained credit cards, they have obtained their own apartments. And with imitation, still the sincerest form of flattery, it's the fact that community courts have opened throughout the United States. There are dozens and dozens of them, and indeed in South Africa, in Australia, in England, and Canada. But for the chief judge, the very best assurance that these courts are indeed working well are the words of the wonderful judges who have for the past 15 years presided over them and see the difference they can actually make in people's lives. When they tell me, this is what I became a judge to do, that sends my spirits soaring. And that brings me to my second problem-solving example, drug courts, basically offering drug treatment as an alternative to incarceration. Today, we have 170 drug treatment courts throughout New York State, a few even in our family courts, offering parents the chance for early reunification with their children if they just will step up to end their drug habit. We offer as well juvenile offenders who are drug addicted a chance to get their lives back on course. Our drug courts actually began in New York State with 4 favorite words of the chief judge. I have an idea. I love people who have ideas. And they don't have to be new ideas. Let's face it. By now, there are very, very few truly new ideas in the world. Ideas, old or new, just have to be right for their time and their place. And this one surely was. Our dockets awash in cases involving nonviolent, lifetime drug addicts going nowhere good, ready to acknowledge that as human beings, they had touched absolutely rock bottom, ready to take the hand offered to them to climb out of the deadly downward spiral. Recently, in an insurance case being argued in the Court of Appeals, counsel answered a question with an insight that struck me as particularly apt. In a Plan A world, he said, the insured, of course, would have given timely notice of the occurrence to the insurer. But we don't live in a Plan A world. We live in a Plan B world, and I've got to tell you, these days, I think we're living in a Plan C world. But it's the Plan B world that really does challenge every fiber of our being, every skill, every ounce of ingenuity, whether the subject before the court is insurance, or drug-addicted offenders, or people in need of mental health services, or domestic violence victims, or my next and final example of things that keep the Chief Judge up at night, kids. Kids in court, kids in the justice system, thousands and thousands of cases involving abuse and neglect, juvenile delinquency. 80% of the children in confinement in New York State are rearrested within 3 years of their release. What a waste. 500,000 of our nation's children in foster care limbo, literally our children, children in our custody. It's their lives, it's their future, but let's face it, it's our lives too. It's our future, it's our nation's future. And here I think the issue is especially relevant for all of us. Collaboration is essential to every problem-solving initiative. Collaboration among justice system leaders, lawyers, social service providers, community groups, even law school clinical programs. Vital as independence is in judicial decision-making, it is our strong collaborations with the bar and the community that enable us to build edifices that honor the past, that settle the present, and that anticipate the future. So I end where I began, with thanks for this opportunity to address you, and thanks to Judge Coffin for inspiring this retrospective. As I contemplate my very next role, I will on January 1 become the first woman former Chief Judge of the state of New York. What a privilege it has been these past 25 years as a judge of the Court of Appeals of the state of New York to apply my professional skills to the resolution of very difficult cases that flood our courts, challenging us in a rapidly changing world to be faithful to the past, to settle the present, and to foreshadow the future. Those, of course, are Judge Coffin's words, from which I draw inspiration, as I do from his example of the great things we can do when we work together. And what a privilege it has been these past 15 years in my other job as Chief Judge of the state of New York, thinking positively, collaborating creatively, finding new ways to address the modern-day problems of so many, whether the issues are poverty, or mental health, or drug addiction, or domestic violence, or child abuse, or juvenile delinquency, or jury reform, or that people have meaningful access to our courts. The challenges are immense, but so are the opportunities each of us have, and all of us have, to do better, to assure that the edifice we call justice does indeed continue to deserve that name. And that, in a nutshell, is my take on the subject of law and public service. Thank you so much. Thank you so much. Thank you. Thank you. Thank you so very much. Thank you. I said, thank you all so much. I said I would be pleased to take questions if any of you would care to raise them. And I think there will be microphones somewhere. Yes? Where's the microphone? Oh, I see. There's a microphone at either end.
Judge Kaye, is there an opinion that you've authored that you're the most proud of, and if so, which is it?
Oh my goodness, I'm always resistant to that. It's like picking a favorite child, so I don't do that. I have the contrary experience in that I very often go back through my opinions now, which cover, let's see, they started in 60 New York 2nd, and now we're into New York 3rd. There are lot of volumes, and I sometimes read them and I just want to tear out some and throw them away. I want to take a pen and edit some, but it would be very hard for me to pick any particular opinion. But the range, I mean, Lee, do you have a favorite opinion?
I have the exact same response. There are a lot I don't want to think about again. And of those that I'm most proud, it's like picking your own child.
Yes, I did have the experience, I don't know whether you've had it, or Dan Wathen or any others, of having a couple of my dissents become the law. Yeah, that is very exciting for a judge. But one was on, let's see, oh yes, it would be long and complicated, but take my word for it, there have been a couple. And in fact, one reversal by the United States Supreme Court. That's very exciting. So I feel for the trial judges and the intermediate appellate judges who have to see their cases come to the appeals court. Don't you, Judge Coffin? It's very painful. When one of our cases, when cert is granted, I want to say, let me come with it. I want to argue the case because I know the lawyers may not do a good enough job, and I want to tell you why we decided this case this way, United States Supreme Court. You would be foolish to reverse us. Anyone else? Mr. Smith, are you going to ask me a question?
No, ma'am. I was actually going to help move the microphone around.
Oh. Yes. Is that Nancy?
Yes. Do you have any advice for judges writing opinions in highly controversial cases?
Well, I think you have to approach every case like it's a highly controversial case, right? Especially when you get to the state's high court. And so I think basically in all my years, I can almost, opinions fall into a couple of different categories. You've heard endlessly about I am a failed journalist. You've heard about my career as a failed journalist, and I believe in clear, simple statements that can be readily understood, and whether the case is about the slip and fall on a patch of ice or whether it's about same-sex marriage or adoption, I just really go for the just plain open statement of what the law is and make every effort to be completely persuasive, and that is so necessary in a high-profile case that and it's necessary in every single case because there's going to be a winning litigant and a losing litigant, and you want your opinion, whether it's a majority opinion or a dissent or a concurrence, you want your opinion to really be an edifice of persuasion. Yes? You want the reader to know, the litigant to know, any reader of the opinion to know that you have considered all the facts, that you have considered the law, and you have rendered a wise and just decision. There's the other category of decisions, which are the ones peppered and laced with adjectives and adverbs and all. Not my style, and I especially hate to see judges fighting with each other. And again, I wouldn't make the distinction between controversial and non-controversial opinions. I think there are general propositions for good appellate decision writing, but it really, I find it very hurtful when I see blistering criticisms. I guess readers, especially academics, love it, don't they? Blistering criticisms in dissenting opinions of the majority writer could not possibly have known the law or been sensible or anything like that. Really a pity because I think it devalues and degrades the entire institution. So I just like the clean, simple, straightforward, but utterly, utterly persuasive opinion. I like to read it and I like to write it.
Thank you.
And you? What about you, Nancy?
Well, I agree completely with the clarity and the application of the law in a way that people can understand. I think something else that matters a lot is making sure that the person who loses, the party that loses, knows that they've been heard. And I think that that can be done by a judge effectively and still render a judgment the
Now,
other
isn't that
direction.
important in absolutely everything we do in the court system? I have had recent experience now with the subject of mediation in matrimonial, in the area of matrimonials. When I became a judge of the Court of Appeals 25 years ago, mediation was a dirty word in matrimonials and family court cases. And over the 25 years, I have seen the growth of the acceptance of attempts to work out problems. And I think what we discovered is that people just want to know that their arguments are heard. They want to speak their side, and they want to know that somebody is really listening to them. And that's true whether it's at the trial level or at the appellate level. But that's what we have to be sure happens at every place in our court system, that people are heard and that they know that somebody has considered their arguments and given them the time and the dignity that a serious legal question deserves. And I think that's generally true. Certainly in the opinions that stand for all time or a good deal of time, the party needs to know that the argument has been fully considered.
And so I
Do you
feel-
do much mediation here in
Oh, there's a lot.
in the matrimonial and child area? But don't you agree that that was once really condemned because the culture has changed enormously? Because I think we came to realize that we could satisfy people, that they were heard, and that's what's important.
Thank you.
Thank you, Chief Judge Kaye. Would you talk a little bit about the new problem-solving court that you're developing in New York with youth courts?
A loaded question, right? Because I've been filling your ear about it outside in the corridor, and I'm very pleased to talk about it. One of the great things about being a chief judge is having friends like Judge Softley, Judge Wathen, when he doesn't injure me with running on the beach. But we come together very often. We learn so much from one another because we really, while we live in vastly different places, we encounter the same human problems, whether we have a large jurisdiction or a small jurisdiction. So much of what we do is the same. What I was telling you about very excitedly was the youth court that I experienced this summer when the Conference of Chief Justices took place in Anchorage, Alaska. As you have heard, I have become tremendously interested in the subject of children, and we have so many in our courts. I was a commercial litigator. I don't know how this happened to me. Why did I waste my youth for 21 years as a commercial litigator? I could have been finding ways to advance permanency for children and just find better ways to treat them from birth all the way through, but make better lives for them. But this summer in Anchorage, Alaska, it's generally the governor of the state that opens the Conference of Chief Justices. This year, the governor of the state did not open the Conference of Chief Justices. She was busy. But the person who opened the conference was the mayor of the city of Anchorage. In fact, I think he's fighting for his political future at the moment against Senator Ted Stevens. But he opened the proceeding with just a powerful description of the youth court being run in Anchorage, Alaska, and it was a great enough presentation to cause me to leave the meeting. I missed the meeting, and I just spent my time in the Youth Court of Anchorage, Alaska, which is a fabulous effort to really reroute adolescents from a life of crime by a program that begins with intensive education in the schools. And Lee, Chief Justice Softley, I'm recommending that you use all the excess funds in your budget to start this right away. I think for $36 million you could do this. But no, seriously, it's an intensive education for high school children in the law, and they have to take a bar exam. this course is complete. And it's just a terrific way to introduce high school people to the justice system and to the courts. Don't we all want to do that? Don't we want to promote civic education? Don't we want to try to turn around this miserable, apathetic public view of what we devote our lives to and try to do so well, the court system, the justice system? We just have such negativity in the public. I think the press is really at the center of this. But anyway, I think we really, this is a great opportunity to get into the schools, get kids interested in learning about the justice system, give them wonderful courses, lawyers and judges. They take a bar exam at the end of the course, and they move on from part 1 to part 2. And part 2 is actually trying their peers, 15, 16, 17-year-olds, for misdemeanors. The case I witnessed was a trial with a 16-year-old who stole a car. Now, that's pretty serious when the people who conducted the trial are 15, 16, and 17-year-olds, but it was very powerful and very effective. The defendant had to plead to the crime, but that was just a small part of what happened, because there was an extensive hearing on what would be an appropriate punishment, and one was evolved, and then a very stern but wonderful person-to-person lecture from a peer on the importance of not doing this again. And I have to believe that that would be enormously meaningful to, well, certainly to the person I watched. And we are doing this in the state of New York. I came back. It's so good to be the chief judge. I came back to New York and I said, let's do this. And they said, okay, we're doing it. So we are doing it. But I'm going to add a third piece, which is a mentoring piece. And I think the lecture that this young man received was, in effect, to tell him that he could come back to the youth court as a judge, as a prosecutor, as a defense lawyer, as a court attendant. He could never come back as a defendant. The next time he does anything like this again, he is going to have a criminal conviction that will follow him his entire life. And it was a very powerful message, very powerful message. The Anchorage court has a better than 90% success rate in that these kids do not reoffend. And I think, you know, we're now well into phase 1 in New York State, and I think we will have some very good statistics, because this is just a great idea. And we have to do more things like this, don't we? We have to use Judge Coffin's example to think. We have to build on the past. We have to have something that's sensible for the present, and we have to always be looking toward the future, to anticipate the future. And that's in everything we do in the court system. That is what we are charged to do.
Thank you so much.
Thank you.
On that positive note,
Thank you.
thank